applicant and the 8th applicant were on bail in case number SCC/265/2018. The 50,000 rand was an of constituted proceeds of unlawful activities. 16. On the 5th of June 2020, applicants 7 to 13 appeared in Court 16 in the district of Tshwane Central. They applied for bail in case number A16/351/2020. Mutre and Associates represented them. After the appearance in court, applicant 1 and applicant 2 and Osiangova paid their legal fees. The funds that were paid to Mutre and Associates were and or formed part of proceeds of unlawful activities, unlawful and fraudulent activities relating to the awarding of the PPA contract to Siangova and or applicant 1 and or applicant 2. 17. I have read the draft charge sheet and I'm satisfied that applicants 7 to 13 are facing, amongst other charges of corruption relating to the gratification or gratifications received from applicant 1 and or applicant 2. They said the applicants did not have authority to receive the assistance in the form of payment of legal fees. I do not have evidence to prove as to who paid for bail for all of them. 8. Offenses of fraud, forgery, uttering, corruption and contravention of the provision of the Prevention of Organized Crime Act 1998, Act number 121 of 1998, are very prevalent in the regional division of Gauteng. I'm advised that in considering whether the ground is in subsection 4A has been established, a court hearing an application for bail may, where applicable inter alia, take into account the prevalence of a particular type of offense or offenses and any disposition of the applicant to commit offenses referred to in Schedule 1. 19. I'm also advised that the 7th applicant and the 8th applicant were on bail in 2 cases when the gratification or gratification was and or were paid. Is a factor that has to be considered by the court hearing this bail application. I'm not aware of any bail condition when the gratification or gratification can prevent the applicants whose applications are opposed from committing other offenses if released on bail in this case. 21. I'm aware that the first applicant is a businessman who is a beneficial owner of several companies that do business with organs of state. I'm also aware that most of his business dealings with the state are with the SAPS. I'm also aware of the fact that the first applicant uses other persons to conduct business with the state, which makes it difficult to somehow prohibit him from getting other contracts because he uses other persons as fronts. 22. The second applicant is a pensioner who was receiving a grant from the South African Social Security Agency, SASSA. SASSA has stopped her payment of the social grant to her after establishing that she is a purported beneficiary of contracts awarded to companies that are ostensibly owned by her. 23. I attach here to a copy of the judgment of the Gauteng High Court, Pretoria, that resulted in attempts to appeal the order of that court. The copy of the judgment is marked Annexure B. Also attached is a copy of the judgment of the Supreme Court of Appeal, see Annexure C. I also attach copies of charge sheet for the Specialized Commercial Crime Court, see Annexure D, in Tshwane Central District Bail Proceedings, transcripts C Annexure E. The fifth applicant has 2 previous convictions, and the fourth applicant has 1 previous conviction. Attached here to are annexures F and G that serve to prove that the 2 applicants who are father and son have previous convictions. 24. The 8th to the 12th applicants have been dismissed from the employ of the SAPS. I am aware that the 7th applicant is challenging his dismissal. 25. I am not aware of any lawful sources of income for the 3rd applicant, the 4th applicant, 5th applicant, and the 6th applicant. 26. The 7th and the 13th applicants have retired from the SAPS. I'm not aware whether those who have been dismissed have claimed their pension benefits. Because of that, I cannot tell whether they have any legitimate ways of supporting themselves. I know and understand the contents of this statement. I have no objection to taking the prescribed oath. I consider the oath to be binding on my conscience. The statement is signed and commissioned by a Commissioner of Oaths. May the statement as well as the annexures thereto be received as an exhibit, Your Worship. As the court please, Your Worship. Your Worship, I'm informed that in 5 minutes' time the addendum will be ready to presentation to the court. May we take a short adjournment?
All right, court.
All silly tricks and Maramako Bulai Lemus. All right. May I proceed and read the further affidavit, Your Worship? In the court for the Regional Division of Gauteng held at the Specialized Commercial Crime Court, Palm Ridge, further affidavit in response to an application for bail. I, the undersigned Sunil Belochin with parcel number 702-74533, hereby declare further under oath as follows. This further affidavit is submitted in response to the bail proceedings related to case number SCCC/09/22 held in Court 7, wherein application for bail were brought by the applicants 1, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, and 13 between the 9th of February and the 10th of February 2022. 3. I was present during the above-mentioned bail proceedings and listened to the evidence that was led on behalf of the above applicants. As a result of what was placed before the court in said bail proceedings, I hereby submit the following with regard to the applicants' applications. 3.1. The first applicant submitted this application for bail in the form of an affidavit which was read into the court record by his legal representative. The first applicant did not disclose to the court his business interests and companies registered in his name at the Companies and Intellectual Property Commission, hereinafter referred to as CIPC. In paragraph 5 of my affidavit dated 7 February 2020, I mentioned and named the 3 companies where he was the director. The SAPS paid Bambanani a total amount of 2,492,015 rand and 92 cents for contracts that were awarded to it. The SAPS paid the semi-billed a total of 2,868,609 rand and 97 rand for contracts that were awarded to it. Sirang was registered as a supplier on the SAPS Polfin system but was not awarded any contract. I did, however, discover evidence that Sirang was involved in cover quoting for goods and or services supplied to the SAPS. 3.1.1. The first applicant did not inform the court that his ex-wife was an accused in Silverton Case 335/05/200 prior to the matter being struck off the roll. The first applicant is the beneficial owner of Mafuta Marketing Solutions, CC, hereinafter referred to as Mafuta, whose sole director was the 5th applicant before it was registered in his ex-wife's name. The SAPS paid Mafuta a total of 3,940,084.65 cents for contracts that were awarded to it. 3.1.2. The first applicant did not inform the court that his girlfriend was an accused in Silverton Case 335/05/2020 prior to the matter being struck from the court roll. The first applicant is the beneficial owner of Impokane General Trade and Distribution Pty Ltd, and after referred to as Impokane. Impokane's sole director is his girlfriend, and she was the sole director of Vatica before it was transferred into the name of 3rd applicant. The SAPS paid Impokane a total of 1,604,667 rand and 13 cents for contracts that were awarded to it. The SAPS also paid Vatica a total amount of 49,661,483 rand and 30 cents for contracts that were awarded to it. The contracts that were awarded to Vatica and Khoto were cancelled by the National Commission of the SAPS. These contracts were awarded to Vatica and Khoto when the 7th applicant, together with the 8th, 9th, 10th, 11th, 12th, and 13th applicants, amongst other police personnel, played active, unlawful, and pivotal role. The first applicant indicated that he is the sole caregiver of his children. I noted that his ex-wife stated in her affidavit submitted during her application in Silverton Case 335/05/2020 that she works for ABSA as a manager and received a salary of 47,000 rand per month plus a monthly support payment of 20,000 rand from the first applicant. In essence, he is misleading the court by saying that he is the children's sole caregiver as the children reside with their mother. 3.1.4. The first applicant did not disclose to the court that he owns a property situated at 167 Steenberg Street, Parfurum Mews 5, Sinoville, Pretoria. The said property was used as the business address of Vatica when it was registered in his girlfriend's name, and later, according to a lease agreement signed by him and his girlfriend, used as the business address of Impokane. Vatica was moved to 183 Maham Street, Kwaggas Rand, Pretoria West, which is also owned by first applicant. Khoto was situated at 199 Besma Street, Pretoria West, Gauteng, which also the registered business address of Umbanati and Super Stationery. 3.1.5. In paragraph 11.1, the first applicant's bail application, He indicated that he was arrested by Brigadier Perumal and myself. This is not true. He was in fact arrested on a warrant of arrest by Warrant Officer PJ van der Merwe on the 4th of June 2020. Both Brigadier Perumal and myself were not present at his arrest. The first applicant is misleading the court by stating that the state has failed in its attempt to enroll the matter before court, referring to Silverton Cas 335/05/200. The state is in the process of obtaining authorization in terms of Section 2, Subsection 4 of the Prevention of Organized Crime Act 1998, Act number 121 of 1998, from the National Director of Public Prosecution to charge the accused in Silverton Cas 335 of 5/2020 with racketeering, amongst other charges. The investigation revealed that the first applicant was running a criminal enterprise made up of several companies registered in the names of people who were fronting for him. In all instances of cover coding and collusive bidding, false and fraudulent triple BEE certificates were used as part of the various bid documents that were submitted to the SAPS. According to the bank records that were subpoenaed, the first applicant was responsible for laundering large sums of money between the 26 companies that are implicated in Silverton Cas 335 of 5/2020, and he was the beneficial owner of the 26 companies. The first applicant stated that a substantial application in terms of Section 342A was done. However, the state had disclosed the contents of the case docket and the draft charge sheet prior to the case being struck off the court roll by the magistrate when the case appeared in court 3 prior occasions and within 9 months of the case being on the court roll. On the day when the case was struck off the court roll, the state joined the 26 companies to the proceedings in terms of Section 157(1) of the Criminal Procedure Act 1977, Act number 51 of 1977. The case was on the court roll for the 4th time, but Mr. Ramabulana and others made the applications from the bar for the removal of the case from the court roll. It is worth mentioning that on that day, Mutre and Associates withdrew as legal representative of some of the accused, and Mr. Ramabulana took over from them with immediate effect and launched the so-called substantial application that was granted by the court. The removal of the case from the court roll raised some suspicions that resulted in the investigations that revealed the corruptions that formed the basis of the case against the applicants in the instant case. As members of the Investigating Directorate, we have a duty to protect the integrity of the criminal justice system, and we conducted investigations because we suspected foul play in the removal of the case from the court roll. Our suspicions were confirmed by the discovery of the evidence in the instant case. The first applicant, 3rd, 4th, 5th, 6th, and 8th applicants instituted frivolous motion proceedings in the Pretoria High Court and instituted civil claims in which they lied, saying that they were acquitted by the court in Pretoria. These events resulted in the spending valuable and considerable time, and it caused delays in the re-enrollment of the case in court. We were forced to spend more time compiling affidavits in response to the frivolous applications made. 3.1.6. I append here 2 copies of the Polfin record of the SAPS, which illustrate the various amounts of monies paid to 24 of the 26 beneficial owned companies of applicant 1, which was disclosed by him to the court, which was not disclosed by him to the court rather. The total paid to the 24 companies amount to 134,701,961 rand and 71 cents. See Annexure H. I also attached here to the CIP's records of the 26 companies. See Annexure I. (3.2.1). The third applicant submitted the application for bail in the form of an affidavit, which was read into the record by the legal representative, by a legal representative rather. The third applicant did not disclose to the court that she is sole director of How Tools Pty Ltd, which was one of the companies that the first, second, and Ngobeni paid the legal fees to Mutre and Associates. 3.2.2. In paragraph 9.1 of the third applicant's bail affidavit, she indicated that she was arrested by Brigadier Permal and myself. This is not true. She was in fact arrested on a warrant of arrest by Captain N. Jacobs on the 4th of June 2020. Both Brigadier Permal and myself were not present at her arrest. The third applicant stated that a substantial application in terms of Section 342A was done. However, the state had disclosed the contents of the case docket and the draft charge sheet to her legal representative prior to the case being struck off the roll by the magistrate. The case appeared in court on 3 prior occasions, and within 9 months of the case being on the court roll, it was struck from the court roll. The third applicant instituted frivolous mooting proceedings in the Pretoria High Court and instituted civil claims in which she lied, saying that she was acquitted by the court in Pretoria. These events resulted in the expending valuable and considerable time, and it caused the delays in the re-enrollment of that case in court. The third applicant omitted to inform the court that she previously offered to testify against the first applicant and made a statement under oath. She also omitted to tell the court that Vatica's account and the accounts of the other companies that were respondents in the case as per Annexure, must be Annexure B, were frozen after the court found that she and the first applicant were awarded contracts by the SAPS as a result of acts of fraud. The second to the fifth respondents were entities through whom the proceeds of the unlawful awarded contracts were laundered. The assertion that the state has no case in the so-called marking case ignores the finding of the Gauteng High Court, the C Annexure B of my statement dated 7 February 2022. I have noted that almost all the applicants keep on repeating that the state has had no case in the markings case. 3.3.1. The fourth applicant submitted this application for bail in the form of an affidavit which was read into the court record by his legal representative. The fourth applicant did not disclose to the court that he is sole director of Umbanati and Superstationary. He stated that he is the owner of a company. Whilst his legal representative was reading his affidavit into the court record, he observed that I was advising the prosecutor about the other companies where he is the sole director. He thereafter only decided to disclose them, realizing he will get into trouble with the court. I submit that if I remained composed and pretended not to have realized that he was not disclosing all his business interests, he would not have done so. I was in court when fourth applicant informed the court that he had no problem with the presentation of the affidavit that did not disclose his business interests fully. I wish to state that we previously charged and prosecuted him with perjury, and is very much aware that if he did not make amendments, he will be prosecuted. 3.3.2. The SAPS paid Umbanati a total of 2,700,173 rand and 45 cents for contracts that were awarded to it. The SAPS also paid the superstationary a total amount of 2,694,324 and 23 and 84 cents for contracts that were awarded to it. All three companies are implicated in Silverton CAS 33505-2020 and are beneficially owned by the first applicant. His offer of 5,000 rand seems to not consider the fact that he is a millionaire in view of the fact that he received more than 5 million rand from the SAPS. In any event, he was fronting for the first applicant, but his financial situation is not dire. 3.3.3. In paragraph 9.1, the fourth applicant's bail affidavit, he indicated that he was arrested by Brigadier Perumal and myself. This is not true. He was in fact arrested on a warrant of arrest by Sergeant L. Mkechan on the 4th of June 2020. Both Brigadier Perumal and myself were not present at his arrest. The fourth applicant stated that a substantial application in terms of Section 342A was done. However, the state had disclosed the contents of the case docket and the draft charge sheet to his legal representative prior to the case being struck from the roll by the magistrate. The case appeared in court on 3 prior occasions within 9 months of the case being on the court roll. It was struck from the court roll. The fourth applicant instituted frivolous motion proceedings in the Pretoria High Court and instituted civil claims in which he lied, saying that he was acquitted by the court in Pretoria. These events resulted in the expending and considerable time, and it caused all delays in re-enrollment of that case in court. I again contend that the state has a very strong case against the fourth applicant in Silverton CAS 335-5-2020, and that the fourth applicant played a major role in the criminal enterprise therein. The fourth applicant is lying that he was contacted before his arrest and thereby learned that he was going to be arrested. The truth is that he only became aware of the arrest when the arresting officer arrived at his residence unannounced. The fourth applicant is the sole director of some of the respondents in the case evidenced by Annexure B of my statement dated 7 February 2022. He is the sole director of Hoto and Umbanati. These companies' accounts were frozen because they received the proceeds of unlawful activities. The assertion that the state has no case in the muggings case ignores the findings of a civil court where the burden of proof is on a balance of probabilities. A thorough reading of the judgment makes it clear that the companies registered in the name of the fourth applicant participated in money laundering. I'm advised that this serves to prove the propensity to commit offenses referred to in Schedule 1. 3.4.1. The fifth applicant submitted this application for bail in the form of an affidavit which was read into the court record by his legal representative. The fifth applicant did not disclose to the court that he is sole director of Blue Voice Consulting Pty Ltd. Whilst his legal representative was reading his affidavit into the court record, he observed that I again was advising the prosecutor about him not disclosing his full business interests. He only decided thereafter to disclose that he is the sole director of Agen. Agen, as explained previously, is one of the companies that applicants 1, to Nsiangoba, paid the legal fees to Mutre and Associates 4. He did not disclose to the court that he is the sole director of ParoX. He realized the same as his father. He realized the same as his father that he will get into trouble with the court. I submit that if I remained composed and pretended to not have realized that he was not disclosed all his business interests, he would not have done so before the court. 3.4.2. The SAP has paid Blue Voice a total of 1,926,477 rand and 85 cents for contracts that were awarded to it. Blue Voice and the fifth applicant were involved in cover quoting to secure the contract for Vatica to mark the first 120 Saps vehicles in the Western Cape. Prior to the tender processes unfolding, where Vatica and Koto were awarded the split tender to mark and demark Saps vehicles. The SAPS also paid the ParoX a total of 105,216 rand and 30 rand for contracts that were awarded to it. All three companies were implicated in Silverton Cars 33505-2020 and are beneficial owned by the first applicant. 3.4.2. In paragraph 9.1, the fifth applicant of the fifth applicant's bail affidavit, he indicated that he was arrested by Brigadier Perimal and myself. This is not true. He was in fact arrested on the warrant of arrest by Sergeant Mkechan on the 4th of June. Both Brigadier Perimal and myself were not present at his arrest. The fifth applicant stated that a substantial application in terms of Section 342A was done. However, the state had disclosed the contents of the case docket and the draft charge sheet to his legal representative prior to the case being struck from the court roll by the magistrate. The case appeared in court on 3 prior occasions, and within 9 months of the case being on the court roll, it was struck off the roll. The fifth applicant instituted frivolous motion up proceedings in the Pretoria High Court and instituted civil claims in which he lied, saying that he was acquitted by the court in Pretoria. These events resulted in the expending and considerable time, and it caused delays in the re-enrollment of that case in court. I again contend that the state has a very strong case against the fifth applicant in Silverton Case 33545-2020, and that fifth applicant played a major role in the criminal enterprise therein. The fifth applicant is lying that he was contacted before his arrest and thereby learned that he was going to be arrested. The truth is that he only became aware of the arrest when the arresting officer arrived at his residence unannounced. The fifth applicant disclosed his previous convictions. Regarding the previous conviction in Kempton Park, he omitted to disclose that one of the charges was one of possession of ammunition, whilst he did not have a license to possess a firearm. 3.5.1. The sixth applicant submitted her application for bail in the form of an affidavit, which was read into the court record by her legal representative. 3.5.2. In paragraph 9.1, the sixth applicant's bail application, she indicated that she was arrested by Brigadier Perimal and myself. This is not true. She was in fact arrested on a warrant of arrest by Captain N. Jacobs on 4 June 2020. Both Brigadier Perimal and myself were not present at her arrest. The sixth applicant stated that a substantial application in terms of Section 342A was done. However, the state had disclosed the contents of the case docket and the draft charge sheet to a legal representative prior to the case being struck from the court roll by the magistrate. The case appeared in court on 4 prior occasions, and within 9 months when it was struck off the court roll. The sixth applicant instituted frivolous motion proceedings in the Pretoria High Court and instituted civil claims in which she lied, saying she was acquitted by the court in Pretoria. The contents of her affidavit in the instant case contradict the submission in the civil claim. I'm advised that because of the fact that we have a duty to protect the integrity of our justice system, charges of perjury are being considered against all those who perjured themselves in their civil claims. I'm further advised that those who perjured themselves in their civil claims and other proceedings are displaying signs of propensity to commit offenses referred to in Schedule 1. These events also resulted in the expending of valuable and considerable time, and it caused the delays in the re-enrollment of that case in court. I again contend that the state has a very strong case against the sixth applicant in Silverton Cast 33545-2020, and that the sixth applicant played a major role in the criminal enterprise therein. 3.6.1. The seventh applicant testified from the witness stand in support of his application. He testified he was refused medical attention. I only became aware of this during the time when he was giving evidence in court. I also saw the document handed up to the court for the first time. I reiterate that I did not refuse nor ignore his alleged request for medical attention. The seventh applicant was a senior police officer with many years of experience. The police cells where he was detained was visited constantly by Saps personnel who are stationed at Silverton Police Station. I submit that they would have reported to them that I had refused him being taken for medical assistance. This type of conduct, I submit, must be viewed seriously by the court as it creates the impression his constitutional right to medical care whilst in detention was refused for reasons not only to himself. The seventh applicant kept on telling the court that he is an expert in procurement matters. It is worth mentioning that when he was in charge of the division SCM of the SAPS, he would insist on what he called the rotation of suppliers. Our investigations revealed that the contracts were rotated only amongst companies beneficial owned by the first applicant. I am advised that the seventh applicant did. Let me start again. I'm advised that what seventh applicant did in favor of the first applicant and beneficial owners, beneficial companies owned by him, could be the reason why Siangoba paid these legal fees in the two criminal cases, court cases. Your Worship, I notice it's already after 3:30. I don't know whether we should proceed, because I see I'm far from finishing the reading. I'm available tomorrow, Your Worship. I don't know about my colleagues for the...
Anybody that is not available tomorrow?
Your Chief, I am for sure available. I indicated on the presentation that but we had the long-standing case which Mr. Bosch insisted that we need to proceed. There's witnesses who are coming from far in that particular case. Therefore, I don't want, I can confirm that tomorrow I will not be in the position.
When is your first available?
I had commitment Monday, Tuesday, but I can sacrifice them for this information. I'm not sure.
Which date can you sacrifice?
Monday, Tuesday, I can sacrifice.
Monday is also available to me, Your Worship. What day, Monday and Tuesday? I can make myself available.
Anybody that is not available on Monday. Please specify not available. Cancel. Not available. Say Monday, there's no way that you can get out of your commitments on Monday. No. Right, so Monday, so tomorrow and Monday is not available.
Tuesday?
Tuesday. When I ask the question, it includes, if you've got something, is it possible for you to get out of that commitment before that was done? Is Tuesday available to everyone?
Just for the benefit of, I see everyone is available tomorrow, but for the benefit of everyone, what I can do, and also taking into account the agency of the bail application, and also taking into account, I indicated to the court that from the 21st of February I'll be having a 3-week commitment in the High Court. Therefore, what I can do, Yoshi, but I will need to be present in Pretoria Magistrates Court tomorrow. So what I can do is to make an undertaking to be here, because I believe at this stage, even if my colleague was to finish reading this affidavit, you are still going to be a matter of argument. Therefore, for the benefit of everyone, what I can undertake is to go to Pretoria Magistrates Court with one of the associates at our office and undertake to be at this court at 12 tomorrow, just for the conclusion of the respondent's case. And then I'll see how I maneuver so that we can get moving with this application, because I'm mindful of what may possibly transpire in the coming weeks, because the High Court matter is obviously that one I cannot move, and I'm mindful that if you not conclude this one, it's going to be a very serious predicament for me and my client as well.
But your High Court commitment, you say, is only from the 21st?
On the 21st. Therefore, Your Worship, it's quite clear at this stage that this bail application is going to take quite some time. Therefore, I can put myself on the block for tomorrow at 12.
Right. My concern is, every day so far, we only get started at about 12 o'clock.
Yes,
We lose at least 2 hours in the morning. Yes, it is so. I deal with 2 court roles every day.
yes.
I had some postponements that I needed to deal with, but for at least an hour to an hour and a half, I was waiting to get started with this matter. Every day we lose a lot of time in the morning that we could have utilized for purposes of this matter. We could have been much further down the path of finalization had we started earlier. Right now, I do not, you told me your commitment has already been done a long time ago with the matter that you have tomorrow.
Yes,
By telling me that our witness is coming from afar,
yes.
which means there's a cost factor and an inconvenience factor. Most people might already be here if they had to travel. So I get annoyed if somebody does that to me when there are witnesses that, and I know you've got a matter and a counsel or an attorney has arranged a date with me, and I only hear that somebody else in another court held their back. I don't think it's fair to the presiding officer, the witnesses, and your other colleagues for the defense or the state in that matter. I cannot ambush them by telling you you must be here. That is not fair towards them. There are other considerations at stake. So, before you commit yourself to this, you need to have an answer, a definite answer. And I cannot wait for you until 12 o'clock. That's not fair towards your clients, other people, and everybody waits. You can't sit and wait tomorrow until we can start only at 12 o'clock. Perhaps or perhaps not. For that reason, I would rather than say let's get a clear date. It's Monday, let's start Monday, but let's start early.
Mr. Chief, the court noted I was here today. And
I know. And on day one, you were the first person that told me that you were ready.
yes.
And your colleagues were not. And I applauded you for that. But I cannot, as I said to you, I cannot ambush a matter where you already have commitments in Pretoria for the sake of this matter, regardless of the urgency. That is not fair to other parties in that matter, and there are cost factors to consider. You mentioned to me when we started this matter on day one that you have other commitments that are coming up. So it appears from your perspective there is a problem tomorrow. That's why I'm saying, is everybody available for Monday morning so we can start early, so we can push and see whether we can finish this matter? But then, was it you? You have a problem on Monday.
Yes, Your Worship, but then if tomorrow then the court decides that we not proceed, then that will give me an opportunity to see what I can work on Monday. So then, if ever then I have an opportunity tomorrow, then obviously then I can put my head on the block that Monday will proceed. I want everything.
So you can commit yourself for Monday.
Yes, I do.
Can everybody commit themselves so we can start early on Monday morning? If I say early, as soon as possible towards 9 o'clock, if we can start with the matter on Monday.
I commit myself that I will be available.
Thank you. Everybody else, you commit yourself to that?
Sit over.
Equally so, Your Worship, I commit myself to Monday as early as possible.
Suitable to the state as well. I see applicant number 9 is raising his hand. I don't know what the reason for this.
Yes, please. Appears that there is some other.
No, absolutely.
Please just deal with the
Yeah, I approach as well, Your Worship.
Sure.
not an embarrassment, Your Chief. Your Chief, unfortunately, I understand it's a bit of frustration from other participants in this case. However, Your Chief, my hands are tied, as the court has already admitted that I cannot compromise the other presiding officer and the other matter, Your Chief. Therefore, I stand by my submission, Your Chief, and I've explained to my client that in any case, Your Chief, it's as I've already alluded, it's not a matter that can be dealt with without proper consideration of its length. Therefore, I don't want a situation where we deal with this matter piecemeal. Hence, I'm committing myself to be here at 9 on Monday so that we can have a full day. Because also the piecemeal proceedings, Your Chief, is also compromising this matter. Therefore, I'm indebted to my colleagues for the fact that I'm not available tomorrow. Therefore, Your Chief, matter can be placed on Monday.
Thank you. Please stand up. Right, the matter is being rolled until Monday, the 14th of February, for continuation of the ordered notification. All of you remain in custody. There is no alternative. Thank you.
Lordship, that was the control. Where's Burma? I want to know if we can take that code file and mark it overnight. Where is it? Your Worship, may we have that file so that the exhibits are not marked so that we can properly mark them?
Advocate, for the sake of fairness, let the reason know.
You must be number 16.
Do the marking today. Yeah.
Kasi for the sake of fairness, let the reason. I can learn a rule to lead it. Also, the government a copy so that they're going to prepare for our response. There is that.
How friendly are they? They're not friendly, these guys. I'm joking, man. Why don't you just give them that one?
Yes, we take one set.
What I'm thinking is just doing a small one, saying doing it with the deed that has been released on bail.
All right, you've got.
Gentlemen, we will have your copies tomorrow. Each of you on Monday.
No. Match.
I don't want to be carrying.
Okay.
Yeah. There's no toner in this building.
Yeah,
Every time we have to
give us one as the legal team, and then we will make our own copy.
KL. There's yeah,
That one has a- oh,
yes, yeah, that's what you can have to.
Right, I'm crazy.
Because bato rana ka yona Kosane man Saturday. It's a Saturday again, it's a Friday.
So you're giving them that one.
Yeah, let them have that one, but still make copies for them, and then bring me the what they call it. Then you can leave. Then
Yeah, you own it.
so that when I come back on Monday,
Make it on it.
right? Oh,
You own it on.
oh, okay, thanks.
Just take the mic.
Be careful whatever you say. Someone said something sensitive, can't the mic
Because I'm
on?
listening.
I'm a Costa Span, it's very sensitive.
Where is this man? His phone is here.
Okay.
Ah, there's it.
Well, please disconnect the mic. I can still hear it. It's live streaming and we're not talking.
So that is the basis of your